Welcome to WeLearn, Virtual Learning Network. This is session number 10, Industrial Relations. Topics which we will cover in this session are Introduction, Industrial Relations, their scenarios, causes of industrial disputes, preventions and settlements of the disputes, collective bargaining, and workers' participation in management. Coming towards the introduction, what exactly the industrial relations are. The concept of industrial relations has a wider meaning. It consists of a set of relations that arises out of functional interdependence between workers and management and between industrial organization and society. Next is industrial relation scenario. Industrial relation plays a crucial role in establishing and maintaining industrial peace in the country. A number of factors such as social, economic, political have influenced industrial relations in our country. After independence, significant development have been taken place in the field of industrial relation. The Industrial Dispute Act 1947 was enacted, which provides for establishment for permanent machinery for the settlement of industrial disputes. Liberalization and industrial relation machineries. What are these? The ongoing process of liberalization make it imperative that suitable changes are made on the industrial relation machinery. The demand for the process of liberalization are: number 1, industrial units should gain competitive strength, and number 2, industrial units should consolidate their past gains. Both of these aims further require that the industrial unit should upgrade their technology, or the new technology are generally labor displacing or capital incentive, these should be added. The industrial unit should shed their burden of surplus labor. Next are the causes of industrial disputes. There are a number of causes which are responsible for the industrial disputes. These are wage and allowance, bonus, personal matters, working conditions and labor welfare, psychological factors, external factors. Coming towards the first factor, that is wages and allowance. The demand for higher wage is the major cause of industrial dispute. सबकी डिमांड होती है कि जितना वो काम करे उतनी उन्हें सैलरी मिले, जितना वो काम करे उसके बदले उन्हें उतना ही मॉनेटरी बेनिफिट मिले. Data that show about 1/3 of the total disputes in the country arises due to the following reasons. That what worker feels. They feel that the existing wages are insufficient to provide a reasonable standards of living. Number 2, wages and allowance have not increased in proportion to the increase in the cost of living. And the last is their wage and allowance are lower compared to that of the worker in the other comparable industry. Thus, the demand of higher wage often leads to trade union activities like strike, etc. The resulting is prolonged industrial disputes. Next point is bonus. The second major cause of industrial dispute relates to the issue of management of bonus to industrial worker. Disputes over the rate of bonus and time and mode of payment have been common. Next is personal matters. Poor personal administration may also cause industrial dispute. In the absence of effective personal management, unrest may result into the disputes. Next is working condition and labor welfare. The demand for improvement in service conditions relating to security of jobs, hours of work, interval, leisure, leave, etc., causes industrial disputes. They are also caused by demand of social security measures. Next, coming towards the psychological factors which causes disputes. The worker's satisfaction with the job is not only based on wage, hour of working and other conditions of employment, it is also based on the extent to which he enjoys his work. His psychologically, how much he is stable there, how much he has adapted the environment in the organization. Next is external factors. The external factors are certain factor which causes directly concerned with the industrial which are directly concerned with the industrial establishment itself. For example, the worker may go on sympathetic strike in support of fellow worker in other establishment. Political factors are the another important external factors which causes disputes. The worker may go on strike to protest against certain legislative measures or government policies. Next are the preventions and settlement of disputes. How disputes are settled, or how do we measure various disputes? These are statutory measures and non-statutory measures. Coming towards the statutory measures, they are divided into three parts, that is conciliation, arbitration, adjudication. So first is conciliation. It is a method which brings about a settlement in dispute through the intervention of the third party. The objective of this method is the speedy settlement of dispute. Conciliation may be either voluntary or compulsory. Under the voluntary conciliation, the state provides the conciliation machinery which the disputes use whenever they require it. Under compulsory conciliation, the state not only creates the conciliation service but also imposes an obligation on the parties to submit their disputes to conciliation service. The conciliation officer has to mediate in case within 14 days and send his report to the government. The Board of Conciliation has to finish its work within 2 months and submit the report to the government. Next is arbitration. Arbitration is the different form of conciliation. In this form, the decision is binding on the parties. The arbitrator gives his judgment on the basis of the evidence submitted to him by employer and the employee. Arbitration is either voluntary or compulsory. Under voluntary arbitration, both the parties will willingness need to go on an arbitrator and submit to his decision. In compulsory arbitration, the parties are forced to arbitration by the government. This is also called adjudication. Next is adjudication. If a dispute is not settled by other method such as conciliation and arbitration, the government may refer it for adjudication. It is the last resort for settlement of industrial dispute. The Industrial Dispute Act 1947 provides for the adjudication machinery by setting up labor courts, industrial tribunal and national tribunal. Next, coming towards the non-statutory measures. Under the non-statutory conditions, there is only code of discipline. The code of discipline came into effect in June 1958. It requires employers and workers to utilize the existing machinery for settlement of their disputes, and they should neither resort to strikes or lockout nor to unfair work practice. The Code of Discipline also specifies the various steps for dealing with industrial relation problem. The government has set up various agencies at the center as well as at the state level to implement the Code of Discipline. At the center, it is the Central Industrial Relationship Machinery. The other two non-statutory measures, namely worker participation in management and collective bargaining. So coming towards the collective bargaining. Collective bargaining is defined as negotiation about working conditions and terms of employment between two groups. One group representing the employers and the other representing employees. The main objective of collective bargaining is to come to an agreement and avoid confrontation. Different types of collective bargaining agreements are: number 1, agreement which are totally voluntary in nature for purpose of their implementation. Number 2, settlements negotiated and settled primarily by the parties but registered before a conciliator in settlement. Number 3, agreement which acquire legal status because of successful decision between the two parties. Collective bargaining is conducted between the three levels, that is the plant level, industrial level and the national level. In the plant level, the negotiations are conducted between the management of the plant and unions of the plant. Whereas in industrial level, several units in the same industry together form an association which negotiate with a recognized industry union. And at the national level, the scope and terms of reference are much wider for national level. The representatives of the trade union and the employee negotiate and arrive at a settlement. Next is the collective bargaining process. The first step is establishing a relationship for ongoing negotiation. The second step is in bargaining process relate to the scope of bargaining. Whereas the third step in the process is carefully structuring which facilitates the parties to reach agreement. Next are the prerequisites for successful collective bargaining. These are: collective bargaining require a degree of maturity on the part of negotiating parties. It requires maturity at maturity in both the parties which are participating in negotiation. Next is the union participating in the collective bargaining process must be strong. Next is both the parties need to have flexibility in making adjustments to the demands made. They need to gather comparable data on wages and other welfare benefits in similar industries in the region. The complexity of the collective bargaining agenda requires experience and skills on the part of negotiators. Next is worker participation in management, that is WPM. Worker participation, WPM, is viewed as a mechanism where workers participate in the decision-making process of an enterprise. This is possible if the workers are treated as partners in the management of the enterprise. The scope and extent of worker participation management depends on the objective set to be achieved by the three actors of industrial relation system. These three actors are the employees, the employer, and the government. In our country, the employees expect that worker participation management will lead to the achievement of security of employment, better wage, bonus, etc. Whereas employers' interest is to minimize profit throughout increased productivity, and the government expects worker participation management to bring about an increase in productivity and peaceful industrial relationship. Next are the schemes of worker participation management in India. Three major schemes of worker participation management have been introduced in India. These schemes provided for the setting up of number one, work commitments or work committees. Second is joint management councils, shop councils, and joint councils. Now, coming towards the work committees. The Industrial Dispute Act 1947 provides for the setting up a work committee with a view to number one, promote measures for securing and preserving good relationship between employers and workmen. Number two, sort out differences of opinion in respect of matters of common interest to employers and employees. Next is joint management councils. The main objective of joint management council scheme are number one, to promote the cordial relationship between management and workers. Number two, to build understanding and trust between management and worker. Number three, to improve the efficiency of workers. Number four, to provide welfare facilities to the worker. And number five, to educate workers to the equipped to participate in these schemes. The scope of the JMC is wider than the work committees. Next are the shop councils. The main features of shop councils scheme are number one, the scheme is applicable to enterprise employing 500 or more workers. Each enterprise should constitute one or more shop councils for the whole unit. Next is the number of shop councils is decided by the employees in consultation with the recognized union. Next is the number of members of each councils may be determined by the employer in consultation with the recognized union. Next is a shop council once formed will function for the period of 2 years. And next is the shop council should meet at least once a month. And last is the chairman of the shop councils should be a nominee of the management and a vice chairman should be elected from the workers. Next are the joint councils. The main function of joint councils are fix productivity norms, resolve matters which are unresolved by the shop councils, see that the production targets are achieved to make optimum use of raw material, and to look after the general health and safety measures of the unit as a whole. Next are the following questions regarding this session. These are Number 1. Name the three principal actors in industrial relations. Number 2. List out the various statutory measures provided under the Industrial Dispute Act 1947. And the last is define collective bargaining. Thank you. Happy learning, we learning.